Good evening. Welcome to Land Title Talk, where we encourage you to text in your questions at 904-501-4481, 904-501-4481, where we talk about real estate, legal matters, and all kinds of fun stuff. I have with me, as always, my brother Rusty Collins from the Law Office of J. Russell Collins, affectionately known as Rusty Law. We have Julie here with us today. Thank you, Julie, for being here with us and keeping us in line. And we're also going to have a special guest, my son Sterling, when he gets here. He wants to be part of the show, so we told him he could sit in with us and add his wealth of knowledge that a 17-year-old can bring. But Rusty, dare I ask, what's going on in your world?
Had two instances where pro se litigants were thinking their chat GPT beats a law degree. And one in court found out the hard way that chat GPT takes LSD and has hallucinations sometimes. Where one of the cases they cited just didn't exist. And the other cases
But chat GTP is, no, did I say that right? Chat
GTP.
GTP.
GPT.
GPT.
Mm-hmm.
Georgia, Paul, Tom.
Yeah. Alphabetical.
I don't know why. I thought they were pretty reliable. I mean, don't you use that?
I use it for certain things like doing Visual Basic programming for Excel when I need something to do some kind of a calculation that's weird.
Okay.
Or if I'm trying to program an Acrobat form. But every time I've ever put in a legal issue, the cases that it spits out, it may have great legal reasoning, but the cases it relies on aren't usually there. They just make them up.
That's so weird.
It has hallucinations. And this person got caught. I didn't know it was not a lawyer at first.
But that's so. I thought chat GPT. I have to look at that. I thought you could rely on that for. It gets the information from the internet.
Yeah, well, but it makes stuff up sometimes. So you need to be careful.
Wow.
And I
mean, chat GPT is AI.
Yeah.
Right.
Well, how about this? I got service of process yesterday on a lawsuit.
Okay.
It is very evident to me that the plaintiff in that, who's pro se, is using an AI model of some kind. I think it's chat GPT.
Okay.
One of the cases that she cited does not exist.
Wow. I bet. But the AI normally pulls from information from the internet, so they're getting it from somewhere.
It makes it up sometimes.
No, I wouldn't believe
guessing.
that.
I've seen it more than once.
Wow, I didn't know that. That sort of changes my whole opinion. I guess all of our jobs are safe for now, anyhow.
Well, but now, even my Lexus AI model that I use, Lexus.
So you pay for that.
I pay a lot of money for that. It helps me, but I still have to read the cases to make sure it's saying what they think it says.
Okay.
It's helpful for the research,
right,
to get me to the right location.
You still have to
quicker.
verify it.
Oh yeah, it's great for getting a quick answer and then having it backed up with some cases that you go look at to make sure they're saying what you think they say, and then you check the resources, and you can do that without the AI model. We've been doing it for a long time that way.
Yeah, you just had to look it up yourself.
We'd look it up ourselves, or we do certain keywords and try to find stuff, but it takes longer.
Right.
This is just something that it's we've had stories of lawyers getting caught this way where they don't
verify
and run.
So now the person that got caught in court was not an attorney. Was
not an attorney, but
said. I mean, it'd be a whole different story if it was an attorney that got caught doing that.
The attorney on the other side, and I was one of them, but it wasn't messing with me. Okay.
Well, use the attorney on the other side.
I was one of the attorneys on the other side, but I hadn't been looking at that because the case or the hearing wasn't about me, but I was just there by Zoom, okay, watching. And the other defending attorney spent lots of hours and time researching what this person was saying, and the one case doesn't exist, and the other cases they were talking about and relying on didn't say what that person thought they said.
Wow. So that attorney for the other side had a field day.
Well, it's called attorney's fees. because I had to do extra work and charge my client for the extra work because you were relying on something that you should know better.
And so they're going to charge the
plaintiff. Okay. So it's just
the pro se person.
Yes, the pro se person, because remember, when you're in court, you're held to the same standard as lawyers.
So if you're pro se, you're
every time you go in front of Judge Janesk, if you're a pro se litigant, even if you're just defending a foreclosure and you don't want an attorney because you don't know what you don't know what you're going to do yet or whatever the reason, that judge will swear you in just like the attorneys. He just says, I don't swear the attorneys in because they've already taken an oath in front of another judge somewhere.
Wow.
So it's very interesting.
But I'm shocked to know that the Chat GPT screwed up on the case. I'm shocked at that.
It's a known problem. If it doesn't know the answer, it can't find it quickly.
It makes it up?
Yeah, it'll make it up.
Well, there you go. I mean, we're using AI for music now.
Yeah.
Having a lot of fun with that. But, sometimes it even messes up,
Well, it's a great tool, but it's not something I'd want to rely on all the time.
Yeah. Interesting.
It's like your Google search does not beat my law degree most of the time. Okay?
Most of the time.
Well, nobody's perfect.
Yeah.
And neither is ChatGPT.
All right. Well, I really was under the illusion that, hey, it's computer, it's AI. It's not going to pull something that's garbage, and I was wrong.
I've had it try to do some programming for me, and it sometimes gets it completely wrong, and you have to go through 4 or 5 different versions to get it close.
Wow.
So it just depends.
Interesting. Welcome, Sterling. Yeah. My son Sterling here from Land Title of America.
Yes, sir.
Yeah. He's been working with us, doing some shredding and deliveries and taking care of some things on the side. He wanted to be a part of the show today to contribute with all of the knowledge that a 17-year-old has. So we're so thankful he's here to contribute today. Yeah. But Rusty, what else is going on in your world?
I'm ready to give the reins to you.
Oh, so dangerous.
I know.
So we have the market is a weird market right now. The real estate market is pretty interesting.
Yes.
To give you an idea, we had Julie, thanks to Julie, had her do a search for me on how many deeds were recorded this month versus how many deeds were recorded last month and how many deeds were recorded the month before that. The month before that, 1,300. Last month, 1,200. This month, how many do you think?
15.
15 what?
100.
Okay, interesting. So 13, 12, 15. 1,200 to 1,300 to 1,500.
Sure.
Okay, and I said that wrong because it was actually 1,300, 1,200. This month, 400.
Wow.
Okay, quite a change. Things happen. It is July, and people are getting ready for school. School starts when, Sterling? You get the one question, you get the answer right.
August 11th. To be honest, I don't know.
All right.
But I think it's August 11th.
August 11th. Okay. Yeah, that's the only question we're going to ask you all night long. But so school starts August 11th. So I think people are doing vacation now. You gotta love Rusty. What do you think he's doing right now? He's checking.
He's checking the date. He's checking the date.
He's probably going to tell me I'm full of crap.
Yeah.
So did I do something wrong, Rusty?
I don't know yet.
All right. You want to check?
I am.
All right.
I think I'm wrong. I really think I'm wrong.
No, he's not checking you. He's checking my number on how many deeds
Oh.
recorded.
Okay. Because
I know it's accurate.
I really
I pulled it today.
think I'm
About
wrong.
450.
That is absolutely nuts.
Okay. So here's my point. The reason I brought that up.
And I did a bunch of them in Ladybird deeds. So,
Yeah. Well, the reason I brought that up, Rusty, is people are becoming very creative in their ability they're coming up with creative ways to sell their homes.
Okay.
Buyers are being creative. Buyers are taking advantage of a buyer's market, or taking advantage of the fact that people who are desperate will tend to do desperate things. Okay. Well, that's deeds, right? Well,
It's just deeds.
Well, see, the problem with you is that I don't want you to be right all the time. So
this thing here says it was 1,580,
What did it say,
1,561
1,500?
deeds.
well, we're talking about we got our stuff from the MLS records. So we're talking about probably realtor transactions.
You're talking about real estate agent
Right.
transactions that were in the MLS. Okay.
So that's what we're primarily relying our information on. But so people are getting creative, okay?
Of course.
And one of the things that they're doing to be creative about it is we're starting to see interesting offers. And here's an offer that we just had to review. Obviously, the numbers are slightly changed to not
Protect the guilty.
protect the guilty. So we have a home that was listed. The price was, let's say, $900,000 listing. Okay. The buyer agrees to pay the $900,000 and will get a first mortgage, private investor, for $450,000, and will ask the seller to hold a $452,000 for 5 years with an option to extend 12 months, or basically 6 years. Okay. Tell me what your feelings about that kind of an offer.
He who cares the least wins.
Right.
So is it a bad offer? I don't know. It depends on the property and the buyer and the seller and what kind of cash flow these people have, what kind of cash flow they expect to have. If you have a first mortgage lender, if that goes bad, that first mortgage lender will probably foreclose rather quickly.
What happens to the
and
second lien holder,
The second lien holder,
which is their seller?
right? The second lien holder is in line to get a surplus if there is one,
If there is, and there will be.
most likely.
Yeah. But how much of a surplus? That's the question, right?
Well, correct.
And here's the other thing that's frustrating. If the seller, if they're, there's no payments to be made on the second mortgage, right? So they're never in default until after 5 years, actually 6 years.
Well, this is a one-pay mortgage.
Yeah.
Well, you can make
0%
it a
interest.
default. If they default on the first, you can make that a default on the second.
That's what I think you would have to do is make a cross default clause to where
Of
if they
course.
default on the first, it's a default on the second, because otherwise you have no leverage. You're basically stuck having to try to pay off that first mortgage.
And that's how you would do it. And that's not an uncommon clause.
So they're going to rent this property for 6 years.
They're going to rent the property for 6 years?
Not the seller. The buyers are going to take this property and rent it out. They're going to put on a rental program, whether it be vacation rentals or whether it be just renting it out to long-term rentals. Doesn't matter which, they're going to rent this property out. Okay. So think about,
Hey, wait a minute. You're telling me that this is a, they're getting private loan for the first?
these buyers are getting a private loan for the first.
That means it's probably a 12% interest loan?
Yep. Mind you, now they got a $900,000 piece of property. They're very transparent that what they're trying to do, they're going to rent it for 6 years out to people, and then after
Right.
the 6 years is up, they're going to sell it and then pay off the seller
Right.
with the provision that
What's the terms on the first mortgage? Is it interest only or what is it?
they don't give the option for the seller to know.
Well,
Now, I obviously told him, I says, part of your counter on this, number one needs to be you don't use their title company. Okay. Because they're, somewhere else. And when something bad happens, you're going to call who gives a crap, right?
right.
Because I said that before. So I said, the first thing you're going to do is counterback that you're going to use your title company local so you have somebody to go to. Second of all, you're going to have to know what the terms of that first mortgage are going to be.
Well, you have to accept the contract to do that. I mean, and there has to be a term of the contract. Otherwise, they tell you to pound salt.
But you counterback. That's got to be one of the terms of the contract.
Yeah, you can make up your own deal. It's whatever,
Right.
but you got to do it.
You got to do it. And you need to have a cross default clause.
Oh, definitely.
Okay. So these are the things that I told them they needed to counter. $450 cash in their hand now is important to them so they can get the next. They're willing to wait 6 years for the other 450, but that other 450 is at great risk. These buyers are banking. They basically state that in 5 years that they can't sell it for $900,000, they get an automatic extension of 12 months.
They get an extension, right? Well, they
'Cause they're really just
that needs to
trying-
be documented very well too, because
Well, yeah.
the option without consideration, you can withdraw it. You can withdraw that option.
So they're just basically saying, well, in 5 years, if we cannot sell it for 900,000, we get another 12 months to come up with that price. The problem, and what they're stating is, if we can't ever sell it, we will deed the property back to you.
That's just a little foreclosure. They got their money,
There's a first mortgage on there.
right?
Yeah. So basically, they've got.
So basically, the seller has a loan on their house. These people have no. This would
They have no skin in the game.
right.
However, I'm suspicious, Rusty.
Well, okay, at 30, okay, if you have a hard money loan at 12% and it's 30 years, that's $4,630 a month.
He has a lot of money.
I don't know what kind of property this is.
This is, I
Single
guess,
family or multifamily, or what
a
is it?
single family, and I'm pretty sure it's going to be vacation rental, and
Okay.
I'm pretty sure it's high end property.
Okay,
Obviously, it's got to be for that price.
that's fine. So what? See, the problem is so the buyer gets into this thing for pretty much free.
Free.
Unless they're in it personally and you have personal guarantees and
No.
it matters to them.
I mean, that's part of the counter. You want personal guarantees. They're not going to give it.
Then this seller needs a different buyer.
You know what I'm suspicious of, Rusty?
What?
Can I tell you what I really wonder? And if I were teaching a class on how to totally scam sellers, this would be one of the classes I would teach. And that is, go in, have a private investor, which is really just your own company, different entity.
Okay.
Loan the $450,000, right? You pay, you do the $450,000 a second with no payments till 6 years is up, right? You have an LLC that only buys this one property, okay? And then when the 6 years is up, you've collected rent for 6 years without any money out of your pocket except for the $450,000.
Well,
You've got a $900,000 property and then what you do is you foreclose. You got a $900,000 property, rented it for 6 years, and you technically bought it. If you get it at the courthouse steps, which you probably won't, you'll get your $450,000 back. You basically rented that property for free for 6 years.
except for the use of the $450,000. You did have a $450,000.
You did, but, okay.
It's a pretty good return, I would
Yep.
think.
You think?
But I guess my question is,
Okay, but
who's
none
advising
of
the
this is-
seller?
Huh?
Is this thing already signed?
Well, I mean, we're in the process of,
Are they negotiating the contract, or
They
have
are.
they signed the contract?
they're negotiating the contract.
Okay, well, then the seller needs to at least understand the terms.
I think the seller does. The seller understands the risk. As long as they do the cross default clause, and there will be surplus if it go to 4. But I'm suspicious, Rusty, of a buyer who's coming in on this deal, borrowing private money from some entity. Their whole purpose for buying this property is to rent it. High-end property, just to rent it.
But they just want to get in and get out, maybe.
6 years they went out. 6 years they want to sell the property and get out. And if they can't sell it for what it's, they'll deed it back. You see my problem here? Doesn't it look suspicious to you?
Well, this deeding back thing doesn't make a lot of sense because I'm getting it back with a mortgage on it.
Well, it's for the $450,000 I got.
Right.
But the terms.
But I didn't get the time
But
value
I'm telling
of the
you,
money.
that's not what's going to happen. They're going to foreclose on the first. Okay. We don't have a precedent. Remember that company was out there signing these long 30-year listing agreements?
Oh yeah.
I can't remember the specifics around that.
They would give you money to have a listing that could, if you went to sell the property at any time for the next 30 years, then they got the listing.
Yes.
And you
And
had
they
to use
foreclosed
them.
on a few of those things, but they
I don't know if they foreclosed.
Yes, they-
enforcement.
No,
There
they
was never a
foreclosed.
lien.
foreclosed on a few of those things. Just to let you know.
There's something different then.
No, it's the same thing.
Okay.
Okay. So with that, we didn't really see that flesh itself out for how many years? I mean, that was around for what, 6, 7, 8 years before it really fleshed out.
It happened, and then I think they've discouraged it. I don't know if they.
I don't think they're doing it anymore.
Well, they got out. I probably lost a couple cases. I don't know.
I see this being one of those things. We're going to figure out in 6 years what this is all about, really.
Could be.
It just looks suspicious.
Could be. I don't know.
Could be.
You gotta understand. I look at this one
Could
like
be.
that's. There are there are cases where this deal might make sense.
That's an official,
It's a step up from depends.
yeah, that's true. Come on, give me your gut on this. When you look at this, what's your gut tell you?
I'd be looking at the players to try to read the players a little bit. There's certain fast.
By the way,
talking
they've got
players.
this nice pamphlet. I mean, it's fancy dancy, dude.
Yeah, I know, but there's another company out there that wants to. If you want to sell your house, they'll give you moving money now, and they have a mortgage on the property, like a second mortgage, and they say if they can't sell it, they'll buy it from you if you don't sell it. Okay,
Right.
and there's a price and everything.
I don't think
And
I
then
really have
they-
a problem with all this.
Well, but
So long as the seller really understands what's going on. And I'm sorry, you should finish your thought, but I guess what I'm trying to say is that I don't want to sound like I'm totally against this plan. I just think that the seller's got to be careful of a few things and understand the risk.
well, I think the seller needs advice.
Yeah.
And you can't give out general advice for that because it depends on that situation.
Right.
Unless the advice is never, ever, no way, no how. If you want to consider it, you need to look at some of the risks that you're taking on and what happens if the world falls apart.
Right. And you're talking about this mortgage plan, and I apologize, I interrupted you.
Yeah, and I'm actually defending this one in court, but this was $120,000 loan, I think. So that was supposed to be, we'll buy it from you later, okay? But they give them, it was like from closing till the day the note was due. It was 92 days.
Okay.
So they loan you 120, but you got 102 because there were costs and fees and stuff on
That's pretty
top,
steep,
which is,
isn't it? I mean, what's the effectual rate on that?
well, it might have been 112, but the bottom line is the interest rate, the way I calculated, came out to 46%.
Whoa.
It's a
Because
zero.
it was
It's
a
zero.
92
day loan.
92-day loan, right?
Yeah. And so I'm defending this, and I'm like, this is criminal. This is loan sharking. And not only should you not be able to get your interest, you should not even be able to collect your principal under Florida statute.
Wow. What
So we'll
county are you
see.
fighting this in?
St. John's.
Really?
Yeah. It's going to be interesting.
And I think people need to understand why would it be a 46? What's the interest rate on the note?
0. It's discounted. Well, you understand there's some fees that are considered loan costs. And it's also weird because this was for the house they lived in, although they were going to move out of it. Okay.
So interest rate,
Is
but
0.
APR is what you're talking about.
I'm talking about APR.
Annual percentage rate,
Right.
which is the cost of the loan plus the interest rate. And so even though the interest rate is 0, when you have cost to do the loan,
effective rate.
is 46%.
Yes.
Wow.
And
And I don't know if those who are listening to this, if you understand that, Rusty, can you explain a little more about how that works? Because based on an annual rate, that's
Right.
12 months.
so,
So if you dumb down the math, if I have a 10% loan, okay, but I require it to be paid off in 6 months,
well, how about this? If I have a 0% rate loan,
right?
it's for $100,000,
Okay.
but you only get 90,
Okay. So it's
and it's all
$10,000.
due at the end of the year. Okay, a 1-year loan.
Right.
Then that $10,000 is the interest over.
So
a
it's
year.
a 10% APR,
right,
which is totally legal.
which is fine.
Right.
Okay, and it's
Okay. I
you
hope that makes sense.
there are some people who have an aversion, mostly religiously, to charging interest on any loan, but they don't
Actually,
have.
I have a friend.
I know
that-
you do.
Yeah, that is
And
that
I've
way.
dealt
They
with him.
cannot charge
They
interest.
will not charge interest, but they will do a discount.
Interesting.
Which, for those of us who work in the financial world, that's the same thing as interest. So it's an interesting situation, but APR is what matters because it's what does that loan cost you representing an
The-
interest rate.
The effectual rate.
Right. But with APR, with the CFPB calculations, it's a little different.
CFPB is Consumer Financial Protection Bureau.
Right.
Okay,
Or the
which is
Dodd-Frank Act.
Dodd-Frank Act.
Okay, and it's actually changed how those calculations are made, and it was weird.
To the benefit of the consumer, I would assume.
That's the idea, yeah.
Yeah. I didn't think anything that Dodd-Frank or CFPB does is for the lender. I don't know.
Right. But there was no CD done for this loan. It's a second mortgage though, but there was no
so you don't have to have a CD, closing disclosure.
For a second mortgage?
Yeah.
I don't know that that's the reason.
I think that's true.
I don't think so.
But
regardless, it has under the loan costs, and it's in a loan cost
By the way,
area.
you can't use CD. You got to say what it is here on the show.
Well, we're not using them for music anymore.
No, CDs, no. Or certificate of deposit.
No.
It is a closing disclosure. That's what that is.
Well, basically, the closing disclosure puts several previous documents into one document.
Right. It combines it all together, part of the Dodd-Frank Act.
Right.
Or
And
the Frank-Dodd Act.
it's supposed to make things better for those of
Or
us
the Butthole Act.
Well, for those of us who have done the old HUD-1 settlement statement with a pencil by hand, balanced it with an adding machine, typed it up, and then had to make changes and do it again.
This is why you are the way you are.
It's like we know how to do these other forms, and now they've changed it. Now things aren't where they used to be.
Right. Okay.
It's actually when you get to it.
So back to your case.
Yeah, if I prove 46%,
How could you not prove? I mean, why wouldn't you prove that?
sometimes it's not the way you always look. Okay, because
O.J. Simpson's running free. Oh, well, not anymore, but
yeah. That one of the fees was a selling fee, but it was up in the loan area. Okay, but it was the same company or an affiliate company.
Hold on a second. Selling fee, were they licensed?
Probably. I don't know.
Well, that'd be an important part of the,
thing
equation,
is,
wouldn't it?
They are an affiliate. You know, when I do APR calculations for a local mortgage broker,
And your percentage rate.
when I'm doing those calculations, I am taking into consideration whether, who am I working for? If I'm representing the lender and I'm required, and it's a requirement, that's part of the APR. If
your loan fee is part of the APR. Yes.
Right. If land title,
excuse me, your attorney fee. I didn't mean to say that right.
But if the mortgage broker or the lender is requiring land title, you're part of the APR. The closing fee is
right.
Okay. There's some fees that are made. You would think they're intuitive, but sometimes they're not.
On this case, though, if they have a selling fee and they're licensed real estate agents,
it's a requirement of the loan.
See, I don't know, Rusty.
That's the requirement of the loan.
Why is it a requirement of the loan? You're telling me the paper requires...
It's weird because they were selling one thing and basically it came out to something else because they were not selling the home. They did not sell the home. Okay? And my people moved. It's just a weird situation. So it's going to be an interesting test case, I think, to see what happens. I think it's going to rest on whether or not that selling fee. It's going to rest on whether the fees that I'm considering to be interest or finance charge are actually considered finance charge.
Are there other fees besides the selling fee?
Yeah, there's like points and stuff too.
Okay. Do those points, if you just calculate those points, where you at?
We're getting closer to almost 18%, but you understand.
Well, that's legal then.
Over 18%. You can't get
not over 18%. I said if it's 18 or lower, or is it 17.99999? What's the rule?
I'm not going to run that one because it depends on how you round.
Right.
Okay. So I'm just saying there are heavy penalties. What I don't understand is how this company who's done other loans, and I've looked at them, is not having this problem. I think somebody screwed up on this one.
Okay.
I think there's an error. But my son, when he moved from Tampa to Jacksonville,
right. Well, that was a reload company.
No. It was a company a lot like this.
Oh, really?
And everything worked as it should have.
Okay.
So the house got sold, the mortgage.
So again, how did they do it? They say, all right, we need to move
it was
now.
A bridge loan.
So we're going to give you a loan for $100 and some odd thousand.
What you need, basically,
which is a second mortgage.
Right.
Okay.
It's part of your equity, and then you use that to buy your new house, so you can sell the old house.
And then when you sell the house, the payoff is
a regular payoff of the loan.
But there's got to be a lot of fees in there. It's not just
there's fees, but there's loan fees, but then it's just interest.
Okay, so it's a straightforward interest.
It's very straightforward.
Nothing funky like this.
No.
Yeah.
Nothing like this.
Because this is basically trying to incorporate commissions with
It's
a requirement
very
on the loan.
weird, and if I get away with this one, it'll be good.
All right, so moving on to example 2, we've talked about the $900,000 purchase price, but the first and the second, right?
Mm-hmm.
Again, I'm not opposed to anybody doing that, so long as I understand the risk. I'm just suspicious about what's going to happen in 5 and 6 years.
But you should not be. It's not something you should be advising people.
I'm not advising. They're countering the offer. They have a realtor.
Okay.
Yeah.
The real
I can give
estate-
my opinion.
Yeah. Okay.
Okay, my non-lawyer opinion.
Uh-huh.
My as I see the world opinion.
Keep that in mind when you're in court.
But so, I mean,
I read a lawsuit today that was talking about the closing agent.
Yeah.
You know,
I'm allowed to have my opinion.
unlicensed practice of law.
I'm allowed to have my
other
opinion.
Stuff.
I can still give you my opinion.
Okay.
But so, in my opinion, is that the realtor should encourage them to have a cross default clause. Okay. Correct.
That would be, yes, but that needs
And
to be in
that
the contract.
the terms of the first mortgage must be disclosed in their entirety. And the seller has a right to back out if the terms do not meet to their satisfaction.
Well,
because-
you just put the maximum terms of this.
Maximum
your-
terms of it. That's
and
a good
your
idea
counteroffer.
too. Yeah.
Here's the thing. If I was representing the borrower on something like this, and the contract was very limited on what it said about the second mortgage,
Mm-hmm.
I would be objecting to everything that was not in that contract. Okay? I would be saying, no, that doesn't say anything about late charge. Okay? It doesn't say anything about a 30-day default. It doesn't say anything.
Well, you're one of
about
those
cross
attorneys,
default.
are you?
Well, yeah.
We're glad.
Read the document. What does it say? Just because something is normal and customary doesn't always make it.
Yeah, it doesn't always,
Enforceable.
but
Well, if the contract says what's normal and
normally
customary,
is
you know, if it says
it's normally customary to have a 5% charge after 15 days.
it
You
can be.
can't fight that on a contract.
Actually, it's 4% if we're talking about a bank loan.
It's 5% if we're talking about a bank loan. It's VA or FH. No, VA and
Fannie
FHA.
Mae.
VA. I don't think FHA. VA is 4%. So
And
Agree to
FHA is
disagree.
4%.
Huh?
FHA is 4%. And I think
I don't
Fannie
think
is
so.
too.
oh, I know that. I don't know. Freddie and Fannie is 5%. That one I'm willing to bet you on. And don't look it up. Bet me first. I've got a car you need to clean in retribution of a bet I
You don't need me
lost.
to clean your car. You won't be able to sell
No,
it.
I just want you to have to pay to have it done.
Mm-hmm.
This is not the time to look it up. You still got to look it up.
Uh-huh.
Such an attorney. No, but it's normally customary would be 5%. Okay, Mr. Attorney Man.
Between 0 and 5%. I'll be darned. I guess it's not a. The
It's
question then
5%.
between it can be 4, but
It can be
It's
on
not
a
a
VA loan.
requirement.
Yeah. My point is that normally customer you can't on a contract.
what day of the month is that?
It's the 15th day.
What day?
What do you mean? What day?
What day of the month is the late charge due?
The 16th.
No.
The 15th.
No.
You talking about the first?
17th.
Why?
The first day is due on the 1st,
Right?
and then the second is the first day that it's late.
You're so.
Then you've got 15 days, so the late charge would be due on the 17th. You pay on the 16th, it's not due.
The late fee's not due. I might have to go with you on that one just because I can't have you look it up and prove it.
Oh,
to me.
I learned that back in 1986.
Oh, did you?
Yeah, it's stuck.
All right, so let's talk about one other offer.
All right.
Okay. So here's the other example. And again, I want to make sure everybody understands. I'm not opposed to anything so long as the seller understands the risk.
And when I advise people, I'm the same way. It's not my deal. It's your deal.
Right.
My job here is to let you understand the risks so you can make an educated choice.
Make an educated decision.
Everything we do has a risk. Driving here today where there was a risk.
On I-4 especially.
It was an acceptable risk, and we took actions to mitigate the risk.
Seatbelts, airbags, driving safely, obeying the laws.
Right.
Example 2. We have a seller who wants to sell their property. They have a mortgage. Okay. The outstanding, let's just say it's a $400,000 property. Okay. And they have $200,000 outstanding on the mortgage. Okay. And the buyers are wanting to, they kept using the terminology wrap, and it's not what it is. They want to buy it subject to that mortgage. Okay. And give the seller a second mortgage for $175,000, and then give the seller cash of $25,000 so they can pay their closing cost and their realtor. They're going to have a trust created. This is going to sound familiar. Trust created in the name of the seller. Okay. And the beneficial interest of that trust is going to be assigned at closing to the buyer. Okay. I had somebody text me. Sorry about that. Assigned it to the buyer. They have a provision in the contract that states that if they do not, and by the way, that second mortgage for $175,000 is 0% interest. Okay. And it's due in 5 years. If they stop making payments on the first or don't pay on the second, they have a provision that says they will quit claim the beneficial interest back to the seller. I don't know if they're going to pre-sign that, and I basically told them, I said, well, you don't quit claim the beneficial interest. You have an assignment of beneficial interest. I also said this is not a wrap. You need to get that terminology out of it. This is a subject to. You're buying the property subject to that mortgage, and I don't really see any problems with this deal so long as, again, the seller understands the risk. I explained to the seller that, and again, not giving legal advice, I'm just saying the technical outcome, if the buyers don't make the payments on the first, it's going to affect their credit. Just like them making the payments on the first will affect their credit in a positive way. But again, they're risking their $175,000. There's no payments. It's 0% interest. I made the comment to the seller, and I told them they need to talk to their accountant, that if you don't have an interest rate on a loan, the IRS still may require you to pay taxes on an interest rate you should have charged. Am I wrong about that?
I've heard that statement.
So like the Loch Ness Monster, you've seen pictures, don't know if it's real or not.
I've seen shadows.
Bigfoot too?
Yeah. So I think there's many ways to interpret it. I think people need to take their CPA's advice.
So just talk to the CPA.
Right.
What's your gut on that?
My gut is...
Catch me if you can?
No. Not with the IRS.
Good counsel there, attorney.
I'd just as soon send a death certificate for myself to them. Let them think I'm gone. But we've had interest rates as low as 2% with banks.
We have, but that was the going rate at the time, Rusty.
Right.
When the rates are at 6%, 7%.
Right. So maybe it gets restructured. The IRS restructures it and says, okay, well, 0% for 60 months at a discount rate, we're going to say 3%. Over that time is this much interest. And then, so this much of if you got paid off, this much was capital gain from the sale of the house. And this much is ordinary income. It's not realized until you get it at the end.
I mean, that could be $26,000 of taxable income.
Could be.
Yeah. So, I mean, I don't know. That's something they need to check with their accountant.
I'm not a big fan of that kind of creativity. I mean,
is there anything wrong with it?
Legally, I don't think so. I've done hundreds
We have.
these deals, maybe
Yes.
thousands. I don't know.
We have done a lot of these deals. And for a person who's in a distressed situation, we've seen these deals.
Well, but there's some rules about distress too. Okay, you gotta
What
be
are those
careful.
rules? Because
If you take advantage of somebody, if
Well,
they consider rescue,
what is it?
mortgage rescue fraud.
it's not fraud.
Well, with mortgage rescue. Okay, and
Okay.
it's been a long time since I've had to think about it because this.
Well,
came up
think
in
about it, because
2008.
that's one of the questions that people have with me is, when is it abusive? If you're willing to negotiate, Rusty, if you're desperate and I take advantage of you being desperate, why would that be illegal?
It can be illegal at sometimes because if you're desperate for money, why can't I charge you 35% for a loan?
I get that.
Okay. So that doesn't make sense.
But I understand that you can't charge any interest rate you want to charge. But the point is that
Why can't I contract for a higher interest rate? Because the legislature said so.
well, but if I come to you and you want to sell your property, and I'm willing to negotiate with you, and you're desperate, and I buy it for $1,000, and it's really worth $20,000, is there anything immoral, fattening, or wrong about that? Because you're desperate.
Well, from what I'm reading, it's civil anyway. Okay, but the person, it's the equity purchase. It came up. It was a big deal in the foreclosure crisis.
Okay.
And that's why the statute came up. It depends on if you're considered a foreclosure rescue service.
Well, as long as you don't advertise that, you're just a real estate investor.
Right. I would just be careful because sometimes if
We
the
have
deal's too
people-
good, then it's probably not a good one deal.
For who?
Well, think about this, when something goes wrong,
Right.
who's going to get looked at the hardest in those things?
The investor.
The investor, the one who's making the
Well,
better end of the deal.
But I still think that there's some personal responsibility. If you own property, I can buy your car for any price I want to. Are there any rules that prohibit a person from
Well,
taking
but
advantage of
remember-
a situation?
This could also be considered mortgage fraud in some instances
Why?
because you have a loan that's got a due on sale clause.
Right. And you're taking
and-
title subject to it. But the benefit of that is any time that we keep property from being foreclosed on is good for the universe. Really.
Could be.
I think it is.
You would think so. I mean,
Yeah.
I think typically you're right, but there are some caveats to that. Okay.
If I find a person who's in distress, who has a house, think about this, Rusty. They have a house, right? They lost a job because of a sickness. They've got grandma in the back room on oxygen. They've got cabinetry they paid for somebody to fix, and the contractor took the money in rent. This sounds like a country song.
It happens.
This happens, right?
It does.
So, and they've got an animal that's sick and for lack of a better word, peeping and pooing in a room.
Mm-hmm.
They can't sell that house.
No, they need somebody who can take that risk and do something with it.
So why would that be illegal? If they're desperate enough to say, man, listen, you give me $1,000, I'll sign a deed. And when I move out in 3 or 4 months, rent free, you all pay me another $15,000. I'm going to be happy.
Okay, that's
Anything-
fine.
Is there anything wrong with that?
No,
Can that be considered predatory? They're desperate.
they are desperate. So there's a concept in law called unconscionability.
Okay.
Okay, and in order for something to be unconscionable under law,
Mm-hmm.
there's 2 prongs to the fork here.
Okay.
Okay, it must be substantively unconscionable, meaning
Define that.
would define that it's got to be a really bad deal
For the seller
for the person.
or for the person. Okay.
And the other part is the way the deal was done was in such a way that there was a desperation that was caused by the other side. Okay,
Caused by what side?
the buyer person.
Oh, so you meaning they made it worse than what it was, or they caused the,
right, or
the
hey,
desperation? Are they the ones that sold the guy the drugs and got him hooked, and now they're buying the property from him?
Probably, yeah. That's interesting.
I know that's a farcical idea, but I mean, some of these people we deal with,
But I'm just saying, it's got to be, I'm negotiating with you in bad faith to cause you not to make your payments. Now you're desperate.
Right.
Okay.
Right. No, that makes sense.
Or
if I was the cause of the issue
right now,
or if I was a person that, hit your mother with a car and then, fired you from your job and then now you're desperate. I came in and made you a ridiculous offer.
It could be. Everything's case by case. I tell you what.
Rusty, that looked just funny.
There are no guarantees. Okay. I guarantee death.
Okay. All right. So
we're all gonna die. That's about it.
So that's the key elements is making sure that you're not the cause of their desperation.
Yeah, you want to be the cause of their desperation.
But that first one now, that's a little harder to define.
I'll tell you what. We had a client.
And I want to interrupt you real quick. You have a client. Hold that thought. Because I preach this opportunity with my investors about take advantage of the 3 Ds.
That's divorce and disaster.
Right. And take advantage of that. And there's money to be made in that arena, because if you don't take advantage of that opportunity, somebody else will.
I understand, but you got to be careful about too good of a deal.
I don't know how that exists.
Well, okay. You have the person who wants to buy tax deed investments.
Okay.
Find somebody in trouble on their property that was actually their mother's property.
Okay.
They basically tax deed's coming.
Right.
And they give them $4,000 for a deed. And it's a warranty deed, but we had to probate mom's estate first to get the deed done.
Right.
Okay. They decide once you've cured the problem, there's no more tax deed sale. The desperation's over, right?
Right.
They get real brave at that point.
Yes, they do. The urgency's passed.
Urgency's passed. And then they file a Chapter 13 bankruptcy.
But the deed's already been conveyed.
Right. But that was a conveyance that happened right before they filed bankruptcy.
Can bankruptcy go backwards?
Oh, yeah.
How many years? Just tell me months, not years.
It's 2 years, but
2 years?
Pretty much. If they can say it being a so-called fraudulent conveyance. But it's not really a fraudulent conveyance, because why they got less than the full value, how's that hurting the creditors? Okay.
Because they were going to lose the property taxes anyway.
Right. So, but
it's still a challenge.
But if it's homestead property, you would get half the assessed value. That's the beginning bid, right?
That's a valid point, dude.
Okay.
That's a very valid point.
So instead of getting $30,000-$40,000, they got $4.
Wow.
Okay. I did this case.
Okay.
And I lost.
You defended the buyers.
Yes.
Yes.
Okay. I was very surprised that this could happen, because that deal was made, and it wasn't like, this person didn't come on the eve of the sale.
Did they have title insurance?
Yeah.
Did the title insurance company make them whole?
I'm pretty sure they had to deal with the title insurance company.
Problem is that they had probably a title policy for what they paid for the property.
I guess, but this was
$4,000 ain't going to do anything for you.
Right. So
this is when you get a title insurance policy for the market value according to the property appraiser's office.
A person in that desperation situation, somebody shouldn't be writing title insurance for it. Okay.
I don't know about that. Listen, there's acceptable risk, and that might be one of them.
I'm pretty sure there was an agreement with the title company.
I'm pretty sure.
Okay. So there wasn't a claim, but I'm just saying. And so the person got his $4,000 back over the term of the bankruptcy.
How long was the bankruptcy?
It was either 3 years or 5 years.
Oh my gosh, that's real. Okay.
Okay.
Tied up a little while.
You got to be careful when you make deals, because if the person on the other end gets the right lawyer that's savvy on certain issues,
right,
you can be disappointed.
But I'm still going to say get title insurance, though.
Yeah.
Get title insurance for the market value, because if they're going to put the time and energy in it. They get that protection. If that deed's invalid,
But remember, this guy paid me money, and I didn't get gypped on my fee.
Okay.
But then he only got his $4,000 back plus.
Get it. That's what I'm saying. Get the title
overpayment.
insurance policy for the full amount.
He's a savvy investor. Win some, lose some sometimes.
Well, I wish we could talk more about this because we could go on forever about this topic.
I think you need to be careful. Don't make too good of a deal.
I disagree with you. Make as good of a deal as you can, man. If they're willing to agree to do it, you do it. Right?
Not everything you agree to. Not everything you agree to is legal.
And I agree with you, but I mean, you got to be fair and equitable. I get that. Okay. You don't want to take a desperate person and just stomp on them. Okay. But still working a good deal is still okay.
You can work a good deal.
Yeah.
Okay.
And I understand what you're saying.
You need to look at how will this look in front of a judge or a jury?
Right. Okay.
Who already thinks you're the scum
of the earth. Right.
Okay. And do you have the right? Do you have the law on your side? So I recommend getting counsel on this stuff, at least so you understand the risks that might pop up on you, and then you can mitigate some of them. Right. I'm in a case now where they're making claims that what was done at closing that don't make any sense.
Right.
Okay. Maybe how you didn't know this person, you were selling the property, you signed a real estate contract. Really?
You didn't know what was going on? Yeah.
Okay, and you did a trust that said this person was the trustee. You didn't know that when you saw it?
Yeah.
And then you signed an assignment of beneficial interest. Did you read that document? And a document that says the mortgage is not being paid off right now. And the contract was the person's assuming or taking over the payments on a mortgage. But you're the person, but the person making the complaining part had recently lost her husband.
Okay.
Was pregnant with her 6th child when the husband was lost.
Wow.
And has 6 kids. Yeah. Okay. All these things add up. How's this going to look in front of a judge or a jury?
It's a valid point.
So, what are you going to do then? So you got to think about it. That's all.
And this is Land Title Talk. I'm Steve Collins from Land Title. 904-501-4481 is my cell phone number. 904-501-4481. Rusty, how do they find you?
904-829-6600.
904-829-6600. And we got my son with me. Hey, Sterling.
Hey.
So, Sterling, it's interesting, Rusty, because I think we were on the radio when Sterling was born, weren't we?
What?
Because weren't we talking about him and his prayers?
He was born in
it was one of his heart surgeries. Anyhow, this Sterling, what's amazing about Sterling is that he is a hypoplasty left ventricle kid, which means that he's had 4 open heart surgeries, almost 15 heart caths.
About to be 16, I think.
About 16, yeah.
About to be.
And pretty much of a miracle. But this community was pretty amazing back when he was born. We had a bunch of people praying for him. This community came together. Sterling was known in this town. Thank heavens for a lot of great people in this town. But he looks pretty normal.
Most of the time.
Yeah, unless he takes his shirt off, then he looks like Frankenstein.
If you do an X-ray, he looks like the Terminator inside.
Yeah, he's all metal.
I just remember looking inside his chest once and seeing his little heart under a piece of plastic. And
and in his first surgery, they actually had him a plastic sewed over his chest with his chest left open.
Right, because of the swelling.
The swelling.
Yeah, there's pictures of that.
He had
pictures of that,
tubes, and it's amazing how our body works, because it takes a really big machine to do what a little lung will do.
Oh my gosh, yes.
Okay, and then they turned him into a junkie, and with the pain meds, of course.
Yep.
And then I remember we'd take turns staying with him at night. And
yep.
I did some zombie walking.
We never left you alone. We had somebody there every moment.
I hope not.
No, we never did. We never left you with the nurses alone. We had somebody there every time. Yep,
every night.
Every moment.
That's good.
And I remember zombie walking around the hospital with him.
Yep.
In the middle of the night.
After they closed up his chest, mind you.
Yeah.
He wasn't walking around with a piece of plastic
just wide open.
No, because then all the wires would be following you around.
But it's like, I remember when he was first born, he just so little perfect little guy.
Yeah.
And then some doctor's going to rip open his chest.
Yeah.
Like, you want to hurt the doctor. But
it's amazing, actually.
It's amazing.
Yeah, he was on the heart-lung machine. Was that what it was?
Yeah.
What's
your blood type?
I forgot.
Yeah, he is the blood type that nobody has.
Yeah.
Oh, that's right.
I can't. I can give my family blood, but they can't give me blood.
Right.
That's the.
We need to find the right person with a blood type and have him take up motorcycle driving without a helmet.
No.
We need a
Yeah. He'll probably be on a transplant list before too long. But
I mean, we're grateful that we didn't have to do a transplant. You know, well, Dr. Joyce.
Yes.
Was a great doctor.
Yeah, Dr. Joyce was a great doctor.
Yes.
They pretty much gave up on his heart, and they're like, he needs a transplant. But Dr. Joyce was like, ain't no way, it's a good heart. And he sent us to Tampa, and we had a doctor there, Dr.
Bleiweiss. Wait.
Well, Dr. Bleiweiss, he's the one that said that you still want, he went with the doctors at Shands and said you need a transplant. It was the Peleweather, I can't remember his guy's name, the calf doctor.
Yes.
In Tampa. But they did a whole bunch of stents and ballooning and stuff, and so he looks great. You know, he works out and does, can't play football. So thank heavens for the coach there. He's a great coach. What's your coach's name?
Coach Rivers. He's awesome.
Yeah, Coach Rivers lets him be the videographer, and so he can be part of the team without having to play. And when you were in 9th grade or 8th grade, I can't remember what it was, you came and was throwing the ball around.
Mm-hmm.
And Coach Potek at the time says, you got to get this worked out, man. He's going to
8th grade. Yeah, that was 8th grade summer.
He'll be a
summer
tight
camp.
end.
Yeah.
Let's call the doctor, see if we can put some kind of wrapping around him and make him play football. And I called Dr. Joyce, and Dr. Joyce like, I'm not even going to answer that question. Click. But so that answer was no. But we're glad to have him. He's a miracle, and hopefully we'll keep plugging forward with that good old half a heart, man. He's chugging along with a half a heart, 2-chamber heart.
Yeah.
He does with 2 what you do with 4. He needs a T-shirt.
Merchandise.
I do with 2 what you do with 4. Yeah, what does that mean? So, but no, so I guess next week might be taking a break, but we might be back. It depends on, I've got some scheduling conflicts right now, so we might be back next week.
I could take over.
Oh, you can take over? The next week shows Sterling. But so we'll probably be back next week. But this has been Land Title Talk. We appreciate you listening in, and we look forward to getting your text. Again, you can text in any questions at any time at 904-501-4481, 904-501-4481. You can also email me your questions at Stephen, Stephen, the biblical spelling, Stephen at golandtitle.com, GOLANDTITLE.com. And we like to address your questions. We'll keep addressing these questions and hopefully can be helpful to you in your real estate needs or your legal needs. So nothing's off limits, I would think, for the most part, especially when Rusty's here. But we look forward to seeing you next week. Thank you.